Alan Spector here, and every Tuesday and Thursday at this time, we bring you our own Fireball. Veteran Orlando attorney Tom Olson with Olson on Law. Good morning, Tom.
Good morning, Alan and crew and WFLA listeners.
All right, our topic this morning, Tom, wills and who you have to leave stuff to. Let's say you got like 3 or 4 kids. A couple of them are great. 1 or 2 of them are jerks. Do you have to leave them all something in your will?
Yeah, Alan, there's a variety of reasons why people sometimes will exclude 1 or more of their children, and that is perfectly okay as long as that child is an adult, meaning they're 18 years or older. You can exclude them from your estate.
Ah, good news. But does Florida law have any requirements about who you have to include in your will?
You must include your minor children and you must include your spouse. Here in the state of Florida, by the very fact of being married, your spouse is entitled to at least 30% of your estate.
So, Tom, I've known people who got married later in life. They have children from previous marriages, kept their finances separate with the idea of leaving what they have to their children. Can they do that?
Yeah, Alan, I had clients like that before. They told me that they are intentionally keeping their assets separate to leave them to their own children. Got married and they have children from previous marriages. And I'll do that for a client, but I'll make them sign a waiver that states that if they pass away with a will like that, their spouse can step in and say, I don't care what his will says. I want what I'm entitled to. And that's 30% of everything.
So, asking for a friend, is there any way around leaving your spouse at least 30% of your estate?
Yeah, Alan, you can do that through a pre-nuptial agreement. You do that before you get married. If you're already married, you can accomplish that through a post-nuptial agreement. In these nuptial agreements, you are simply waiving a right to receive 30% of each other's estate. If you do a nuptial agreement and you still want to leave something to your spouse, you're welcome to. You're just no longer obligated to under Florida law.
All right, excuse me a moment. Note to self, nuptial agreement. Hey, if you have legal questions about this or anything else, Tom will be happy to answer them on the Olson on Law show, which is heard Saturdays at 10 a.m. on our sister station, 96.9 The Game. A reminder, Tom and I do these Tuesday and Thursday morning segments on Zoom, and you can watch the video live or later on Twitter and Facebook. Tom, thanks very much, and we will see you next time.
Thank you, Alan.
And remember, for all of your legal needs, call the Olson Law Group in Orlando.